The legal showdown between Blake Lively and Justin Baldoni, sparked by their collaboration on the 2024 film It Ends With Us, has reached a pivotal moment with a federal judge in New York dismissing Baldoni's $400 million defamation and extortion lawsuit against Lively, her husband Ryan Reynolds, their publicist Leslie Sloane, and a separate $250 million libel suit against the New York Times. The ruling, issued on June 9, 2025, by U.S. District Judge Louis J. Liman, was celebrated by Lively's legal team as a total victory and a complete vindication, branding Baldoni's claims as a desperate attempt to silence her allegations of sexual harassment and retaliation. While the decision marks a significant blow to Baldoni, the judge granted his team until June 23 to amend claims related to breach of implied covenant and tortious interference, ensuring the saga remains unresolved as it heads toward a March 2026 trial. The feud began in December 2024, when Lively filed a complaint with the California Civil Rights Department, accusing Baldoni, her co-star and director, of sexual harassment during the filming of It Ends With Us, a romantic drama tackling domestic violence that grossed over $351 million globally. Lively alleged Baldoni made inappropriate comments, engaged in unscripted physical actions, and fostered an unsafe set environment. She further claimed that after raising concerns, Baldoni, alongside Wayfarer Studios, producer Jamie Heath, and publicists Jennifer Abel and Melissa Nathan, orchestrated a smear campaign to undermine her credibility. Her federal lawsuit, filed shortly after, accused Baldoni of harassment, retaliation, and emotional distress, framing him as a director who weaponized his authority to suppress her voice during a contentious press tour plagued by rumors of on-set. Discord.Baldoni countered on January 16, 2025, with a $400 million lawsuit against Lively, Reynolds, and Sloane, alleging defamation, extortion, and invasion of privacy. He claimed Lively's accusations were fabricated to deflect criticism from the film's troubled promotion and to seize creative control, including over the final cut. Baldoni's suit argued that Lively, backed by Reynolds and Sloane, threatened to withhold promotion and attack his reputation unless he relinquished directorial authority. A separate $250 million libel suit targeted the New York Times for its December 2024 article, which published text messages allegedly showing Baldoni's team planning to bury Lively. Baldoni's attorney, Brian Friedman, insisted the messages were taken out of context, and his team launched a website, thelawsuitinfo.com, in February 2025 to share untampered evidence supporting his narrative. Judge Liman's 132-page ruling dismantled Baldoni's case, finding that Lively's statements in her California complaint were protected under California's litigation privilege, rendering them immune from defamation claims. The judge noted Baldoni failed to prove Lively made defamatory statements beyond her protected complaint, or that Reynolds, Sloane, or the New York Times acted with malice, a key requirement for defamation. Liman also dismissed Baldoni's extortion claims, characterizing Lively's alleged threats to renegotiate terms or skip promotion as legally permissible hard bargaining rather than criminal conduct. A claim tied to a document Lively allegedly never signed, which Baldoni argued obligated her to promote the film, was rejected for lack of contractual evidence. The Times reporting was shielded by fair report and litigation privileges as it accurately reflected Lively's allegations. However, Liman allowed Baldoni's team to amend claims for breach of implied covenant and tortious interference by June 23, offering a slim chance to salvage parts of the suit. Lively's legal team, led by Ezra Hudson and Mike Gottlieb, hailed the dismissal as a decisive win, vowing to pursue attorneys' fees, treble damages, and punitive damages against Baldoni, Wayfarer Studios, and financier Steve Sarowitz for what they called abusive litigation. Leslie Sloane's attorney, Sigrid McCauley, emphasized her client's vindication, arguing Sloane was unfairly targeted to tarnish her reputation. The New York Times, through spokesperson Charlie Statlander, welcomed the ruling as a defense of honest reporting, rejecting Baldoni's suit as a meritless attempt to suppress journalism. Lively addressed the decision on Instagram, describing the pain of a retaliatory lawsuit and framing her fight as a stand for women's voices, tying it to broader issues of workplace accountability in Hollywood. The dispute has unfolded as a public spectacle, amplified by the involvement of figures like Taylor Swift. In May 2025, Baldoni's team attempted to subpoena Swift, alleging she was present during discussions about a scene Lively sought to revise, claiming Lively used their friendship to influence set dynamics. Swift's team dismissed the subpoena as a tabloid clickbait stunt, and it was withdrawn after objections from Lively's attorneys. The move reportedly strained Lively's relationship with Swift, who has since distanced herself, adding a personal layer to the drama. Another twist came on June 7, 2025, when a reporter admitted a text message claiming Sloane accused Baldoni of sexual assault was erroneous, as Sloane denied using the term, weakening a key pillar of Baldoni's defamation case. The case has also exposed broader industry tensions, particularly around consent and power in the Me Too era. Lively's allegations of body shaming and inappropriate conduct carry weight, given the film's focus on domestic violence, spotlighting the role of intimacy coordinators in ensuring safe sets. However, Baldoni's team argues Lively's active involvement in choreographing intimate scenes, directing camera angles, pacing, and Baldoni's movements undermines her claims of discomfort, raising questions about responsibility when actors wield significant creative control. Public sentiment reflected in X posts is divided. Some celebrate Lively's victory as a win for survivors, while others note the judge's allowance for amended claims keeps Baldoni's case alive. Critics like R. Ely Zimmerman have questioned whether the ruling reflects a two-tiered justice system favoring the elite, though such claims remain speculative. Lively's legal maneuvers have faced scrutiny as well. On June 3, 2025, she withdrew claims of intentional and negligent infliction of emotional distress after Baldoni's team sought her medical records, a move her attorneys called routine, but which Judge Liman refused to dismiss on her terms, warning that failure to withdraw could limit her evidence at trial. Lively's team has accused Baldoni of scorched earth tactics, while Baldoni's camp, through Friedman, has pushed back, alleging Lively and Reynolds manipulated the narrative, even pointing to Reynolds' Deadpool and Wolverine character. Nice pool as a mocking jab at Baldoni. Both sides have resisted settlement, with a February 2025 letter to Liman confirming their intent to proceed to trial on March 9, 2026. The case's fallout extends beyond the courtroom, reshaping perceptions of Lively, Baldoni, and Hollywood's accountability culture. Lively's Time 100 gala speech on April 24, 2025, emphasized using her voice for good, a subtle nod to the dispute. Baldoni's team, meanwhile, has faced backlash, with his former publicist, Stephanie Jones, refuting claims she leaked texts to Lively, stating she was legally obligated to comply with a subpoena. As Lively prepares to testify and Baldoni considers amending his claims, the case underscores the complexities of navigating consent, power, and public relations in modern filmmaking, with potential to redefine industry standards for workplace transparency and accountability.